They had smash hits and put Miami on the music map. You've heard the beat.
It's as soon as you hear it, everybody goes, "Oh, that's my."
Multi-millions of dollars. Multi-millions of dollars.
But they got nothing to show for it. They say a major record company are taking their licensed songs and making money off of it, from commercials to movies, even sampled by your favorite artists.
Somebody has our music. Somebody's getting paid for this music.
This man says he owns the original rights, but he got in trouble with the law and went to jail for 20 years. A perfect opportunity for the songs to be taken.
We are essentially fighting for creatives and innovators all over the country.
It's a fight so big that the Supreme Court has now taken the case, and it could change the music industry forever. I'm Justin Carter. This is TSR Investigates. There's a copyright battle brewing right now, and at the center of it is this song. Take a listen. That's Pretty Tony's Jam the Box, which sounds a lot like Flo Rida's hit song called Ayer, featuring will.i.am. And attorneys say that track and several others have been generating millions of dollars over the years, and the songwriters and publishers connected to them are not receiving a fraction of that revenue. So it's led to a fight on the Supreme Court level that could really shake up how we look at copyright infringement, and something too that people who post, share, and create content need to pay attention to. The mid-'80s was good to Garfield Baker and his group Freestyle Music. There's no doubt that their hits have become timeless, as they're still selling out venues.
Everybody scream! It took off to the point where we were selling more records than we could actually manufacture at the time.
Pumping out hit after hit under his label, Music Specialist Inc.
It was almost like a hip-hop, urban, Latin kind of fusion of genres that we were able to create.
But a drug charge against the label's founder and CEO, Sherman Neely, put everything on pause. He was sentenced to 20 years in prison and eventually did serve his time. He got out in 2015 and heard the song Ayer, Flo Rida featuring will.i.am. It was a mega hit, and Baker says it sounded familiar. It was sampled by his label mate, Pretty Tony's Jam the Box from 1984. Around that same time, Baker and his Freestyle group mates had a hit song too called Don't Stop the Rock. And it started being used in commercials. And even movies.
Wait a minute, you know what I'm saying? That's my song. I should be getting some money. Why is nobody calling me about a check? How did this happen? Music business kind of built that way, where we take advantage of the talent.
He and his bandmates, they talked about it, not knowing where to start in blowing the whistle. They called their old boss Sherman Neely.
And pretty much I kind of thought that he was crazy. And because it'd been going on so long, and the music was old.
One thing he says he did right before he went to prison was make sure that all his paperwork was in order, including registering the songs he published at the Copyright Office and securing licenses. But he wasn't being compensated properly. So he took his concerns to a team of lawyers in 2018, where they sued Warner Music's Warner Chappell, Artist Publishing Group, and Atlantic for the copyrights for 14 songs co-authored by Garfield Baker, Byron Smith, and Sherman Neely between 1984 and 1987. Here's one of Neely's attorneys on the case, Chelsea Lewis.
This happened during a period of time when Mr. Neely was incarcerated and physically unable to recognize that his rights were being infringed upon by the use of his music without proper permission.
But the fight hasn't been easy. For 6 years now, the case has divided federal courts over how copyright laws apply to this.
This issue that has now made its way up to the Supreme Court is whether creatives like Mr. Neely should be limited in their damages only to the 3-year period prior to filing suit. We, of course, disagree with that based on the plain language of the Copyright Act, which says that Mr. Neely and others are entitled to their actual damage with no 3-year limitation.
They were pleased when the Supreme Court, the highest court in the land, granted a request to consider whether damages are owed and how the discovery rule applies here.
Anything that you create from your soul or from your intellect is property. That's why they call it intellectual property. We're talking about multi-platinum albums, box office movies, TV shows. We're not just talking about pennies, nickels, and dimes. We're talking about they've been making a lot of money, you know, off of this catalog.
And it's unfortunate that it's taken us this many years and this many resources and literally a trip to the United States Supreme Court simply for Mr. Neely and those who participated in creating this music to be having the opportunity to have their rights recognized.
This all comes on the heels of a lawsuit filed just last week against Universal Music Group over the hit song Real Love by Mary J. Blige. Mary J. Blige was not named in this lawsuit, but a company called Tough Records, they accused the Universal Group of sampling their track Impeach the President from 1973 without their permission. It's still, though, unclear why it took them 30 years to file that lawsuit. In Sherman Neely's case, though, we did reach out to Warner Chappell, we reached out to Atlantic and the Artist Publishing Group about this. We're still waiting to hear back, and as soon as we do, of course, we'll relay it to you. For TSR Investigates, I'm Justin Carter. Hello, roommates, and thank you for watching our YouTube channel. Do you want more TSR Investigates? Be sure to subscribe and check us out at theshaderoom.com.